Good evening, Captain Retired Matt Edwards here at Next Observation Post Facebook Live weekly update. I'm going to do 3 items on my numbered list. Then I'm going to talk about taxes again. Taxes seems to be a lot about what I'm talking about. Because I think that, the tax system is not fair to the disabled. Not so much, well, I'm not going to get into stuff about healthy people. And if you're healthy enough to put away money, say, contribute money to the government, well, that's life. Taxes are what the government needs. Anyway, numbered list, number 490. Failing to deduct and remit Canada Pension Plan contributions since Bill C-13 means that the Canada Pension Plan disability cannot be clawed back from IRB or SISIP et al. They harm the Canada Pension Plan, which is bad public policy, so they have no right to claw back. Who is liable? Can Manulife, as administrator, be held liable? Now, what I'm talking about there is that the government, Canada Revenue Agency, wants long-term disability insurance, which it considers to be income, to have Canada Pension Plan and employment insurance taken out of it as well, because they take that out of income. But it's not income, it's insurance. Now, I'll get into that a bit more later, because I plan to talk about the Carter Royal Commission. And that was when they decided to tax long-term disability insurance. And I found that report yesterday or the day before, and lo and behold, it's not as it seems. It's not what I thought it was. Number 491. Pensions cannot be assigned to another person, I'm pretty sure I meant. Canada Pension Plan disability assignment is dangerous public policy and must stop. Now, what I'm getting at is that an assignment is when you give the right to something to somebody else. Now, if I wanted to give the right to my Canada Pension Plan disability to my son, well, they say that I can assign it to Sun Life or Manulife so that my retroactive money will go to those companies. So they have opened the door for an assignment of a pension, which is not normally legally possible. Because Canada Pension Plan Act, Section 65, brackets 1, says you can't do it. The Financial Administration Act, Section 67, says you can't do it. But if they can do it for these companies, which have no connection to me at all, why can't I give it to somebody that I want to give it to? Just food for thought. They don't seem to realize sometimes what kind of a can of worms they open up. Number 492. Canada Pension Plan's irrevocable consent makes any other clawback clearly off limits. A waiver of Canadian Forces Superannuation Act, Section 15(2)(b). For example, as the government embarked on a bad public policy in 1993 without thinking of the ramifications of their own designs. This form makes Veterans Affairs Canada and the Canadian Forces Superannuation Act clawback of the Canada Pension Plan disability retroactive highly unlawful. Now, what I'm getting at, and I've discussed this briefly before, I'm pretty sure, is that when the government was lobbied, I'm sure that the insurance industry lobbied the government to insert Section 65(3) into the Canada Pension Plan Act. By the way, that section of the Act doesn't give them the right to take into account future payments, but it gives them the right to get the retroactive payment sent directly to them, which is what I was talking about with the assignment of rights, the assignment of the retroactive payment. So, when you think about it, there's interactions like the Canada Pension Plan and the Canadian Forces Superannuation Act. Section 15(2)(b) of the Canadian Forces Superannuation Act says if you're getting a Canada Pension Plan, we're going to reduce your Canadian Forces pension. Now, before 1993, they would have a stronger argument to say that we wrote this law and these these pensions are integrated. But after 1993, the government of Canada put into the act that they can send a direct payment to somebody other than the Canadian Forces Superannuation Act pension administrator. So the Canada Pension Plan Disability Retroactive gets sent directly to an insurance company many times, and therefore the government decided that private companies come before the government itself. Now, to some, this might seem weird. I think it's kind of strange, but at the moment, they're both doing it. So you could get your retroactive Canada Pension Plan, and then Canadian Forces Pension will send you a bill, and Veterans Affairs could send you a bill, and SISIP could send you a bill. I'll give you an example from my own Canada Pension Plan Disability. I got $14,351. Sun Life wanted it because I didn't sign the irrevocable consent form. Manulife told me I had to send a check to them. So now I got $14,351, but I'm already down twice that because each of those insurance companies wanted the money. Not to be outdone, the Public Service Superannuation Act pension, they sent me a bill for $9,800, and then the Reserve Force Pension Plan sent me a bill for $909. So when you look at the fact that I got $14,351 of my own money back because pensions are property, well, I lost $39,000. So how is that equitable? How is that fair? Well, I'll answer it was a rhetorical question. It's not fair. It shouldn't be allowed. No one should be put in the hole because they're disabled. They're profiting, they're making a windfall on the backs of the disabled, which is reprehensible. Now, I'll close this down, and I'll have a look at the other issue I was going to talk about. Because this guy Carter, okay? I didn't know much about him, so I Googled him today, and I saw a little bit about him, and he was an accountant. I thought, he would have been a member of Parliament, or a judge, or a lawyer, or something like that. But they'd set up a John Diefenbaker, according to the, let me see if I can find that picture now, the Carter Commission. Now, I found this, and it was on taxwealth.ca, was the website. And they said, Progressive Conservative Prime Minister John G. Diefenbaker appointed the Royal Commission on Taxation in September of 1962 in response to complaints about the high level of taxation in Canada. He chose Toronto accountant Kenneth Carter as the chair and appointed J. Harvey Perrott, Executive Director of the Canadian Tax Foundation, A. Emile Beauvais, Executive Vice President of the Quebec City law firm, and then they list off a bunch of other people. Now, this might come as a surprise. I'm not a lawyer, but the Income Tax Act is law. So it seems to me if you're going to review the Income Tax Act, you ought to appoint a judge or a lawyer to head the commission. That's the first thing I'd think of. Now, as far as I know, very few recommendations of that Carter Commission were accepted by the government. Now, the government does have lawyers. Maybe they looked at it and thought this buddy was out to lunch. But according to the CPPD, Supreme Court of Canada case in 2005, they talked about the Carter Royal Commission, and they said that, they brought in this tax on income replacement. Well, no, that wasn't what the Carter Royal Commission was talking about. Now, they gave the reference, so because I had found the Carter Royal Commission report, I went to the section that the Supreme Court of Canada said they talked about taxing income compensation. And they said that they recommended the taxation of damages. Well, no, that's not how I read it. Now, I only skimmed it, but I did a keyword search. And they said something about taxing damages as income or capital, but you see there's a difference between income and capital, because damages, now the Carter Royal Commission started in 1962, but the Jennings 1966 Supreme Court of Canada case said that damages were capital and they could not be taxed as income. So you can't say in a common law democracy, we're going to go against the Supreme Court of Canada. You can't do it. For one thing, it'd be legally incorrect, because if you want to tax a sum of capital, you have to use the capital taxation rules. So, you have to have your starting price. The starting price of your body is you own it. So it's what it's worth. And then if you get hurt, the judge determines how much damages you get, and the payment is supposed to make you whole or balance the scales. There is no profit in a tort damage award. So you can't tax it as a capital gain, because it's not likely you're going to actually get what you're owed. You'll probably only get a fraction of that. Now, some of the other things that I found very disturbing is that the chapter, the part that they were talking about, if I find it here in a second, I'm scrolling down through, it was in chapter 16. And the heading, the title of that chapter, is deferred income. Now, deferred income is like a pension. Okay, you work for your employer. You get so much money now, and they put so much money away for the future. They defer the income from the present into the future. And there's no guarantee you'll get it. You could die. The company could go bankrupt or something. The world could end or whatever, but there's no guarantee you'll ever get it. But the chapter that this guy wrote in the Royal Commission on Taxation, published in 1966 after 4 years, he included long-term disability insurance into deferred income. Now, caveat, I can actually agree with that in a way, because in Supreme Court of Canada cases and other court cases, pensions have been likened to insurance. So if you're getting a pension and you become injured and you sue the person who injured you, they cannot take your pension into account because they likened it to insurance, and they brought it in under the Bradburn rule, which is called the insurance exception rule. And you cannot take insurance into account to reduce somebody's damages, to give them an advantage because the person became disabled because of their actions, and that person had insurance or a pension. You can't very well give them a break on the damages because they have provided for themselves with some form of insurance or a pension. You can't do that. It's illegal, unlawful in the common law. So let me see what he says. I'll skim on through it, seeing I got nothing else to talk about, and I said I'd talk about the report. In this chapter, we will deal with the tax implications of deferring the use of income. The most common deferment is the organized provision for retirement by means of a contractual arrangement, which requires a setting aside of income for later use. Now, aside here, editorial comment, when you put away income for future use, that income might have been income when you received it, but after you receive it, it is property. And I can tell you there's a case from, I think, 1983, Supreme Court of Canada that says that income is property, by the way. It was about a native on a reservation. The principal examples are pensions, profit-sharing plans, annuities, and similar forms of savings. See, so he says it's property, savings. For our present purpose, we shall refer to such arrangements as retirement income plans. In addition, most permanent life insurance has a substantial saving element. Now, by the way, this was pre-Canada Pension Plan, 1962, and it was released around the time the Canada Pension Plan was agreed to. The second paragraph. There is also a second general form of contractual payment plan in which the saving element is, if anything, is normal. This is primarily a means of protection against the immediate loss of income from an unexpected adversity and is not intended as a form of savings. Now he's talking about long-term disability insurance, obviously. Examples are unemployment insurance, supplementary unemployment insurance, workman's compensation, weekly indemnity, and group life insurance, sickness and accident insurance, and other income protection insurance, all of which provide a substitute for the regular income streams when, for some reason, it ceases. Now that sounds logical, except all of those things are probably what the Supreme Court of Canada has said in the Whitten versus Pilot, Supreme Court of Canada, 2003. Insurance is bought to provide peace of mind. Now, the means to the peace of mind is the insurance payments. So it's not to replace your income, it's to give you peace of mind with the payments that are supposed to be made. Now, I don't like them grouping workers' compensation in there because that was bought with the right to sue. So it's a replacement for a tort lawsuit. And it's not exactly like this stuff. And unemployment insurance, well, that's the social insurance. So, anyway, group life insurance is included in this classification because of the administrative advantages in treating it in a similar fashion to other forms of employee benefit plans. We shall refer to such plans as income insurance plans. So, Supreme Court of Canada said in that case I mentioned, see a preface, that they were talking about income replacement. Well, they must have read into it because they didn't say here that it was income replacement. Well, they said it was income insurance. Now, see, this is the thing. I've been saying forever that why does the government call the income replacement benefit that term? It's really insurance. And the service income support insurance plan. They can call it an earnings loss benefit. They can call it an income replacement benefit, but really it's insurance. We shall refer, he said, to such plan. Oh, I already did that. About as in income insurance plans. Now, CRA called it in 1979 wage loss replacement plans. Although arbitrary distinctions of this nature are imperfect, and certain plans would contain elements of each, retirement income plans are considered primarily with long-term income maintenance. That's another term I hear a lot with this stuff, and it's often used in divorce as well, maintenance. Anyway, the thing I'm trying to get at is that it seems to me that the Supreme Court of Canada wants the government to tax the disabled. And the problem with taxing the disabled is that we have a thing called the Charter. Now, the Charter of Rights and Freedoms is supposed to guarantee that laws will not place a burden on the disabled in Section 15(1). So the way they phrase it is that the law cannot be used to, in or under the law, be put on a disabled person. Any law that is not in keeping with the Charter of Rights and Freedom is void. What they say is it has no force and effect. Now, until somebody brings it to court and proves that the government is mistreating the disabled with the Income Tax Act, Section 61F, we are kind of stuck with this shit. And when the law was made in 1971, there was no Charter of Rights and Freedoms. But there has been since 1982. So I can see a class action, or a single individual lawsuit if a class action is not possible on tax issues, for example. But there's a guy named Bruce Bryan. He was getting the Public Service Management Insurance Plan, which is a long-term disability of the federal government. And they sent him T4As that he shouldn't have got. Now, the insurance company was alleged to be National Life, but it was really the government of Canada. And he ended up getting $60,000 in punitive damages on $7,000 or $8,000 of taxes that he owed. Now, that's a precedent. Now, why are the other 3 long-term disability plans not tax-free, like Bruce Bryan's tax-free long-term disability insurance? The only thing I can think of is that they're hoping we don't see and kick up a stink about asking to be treated fairly. Now, okay, now here's the part about income insurance plans in the same chapter. Although plans falling within this general classification, for example, unemployment insurance, supplementary unemployment insurance, workman's compensation, sickness and accident insurance, and group life insurance, do not contain a large savings element, so that the relative size of the property income involved is small, the insurer does benefit from lower premiums because of the existence of some investment income. So according to this idiot, he's trying to say that there's some connection to investment income for the payment of a long-term disability insurance. That goes against all logic to me. Isn't the price of the premium supposed to be pooled? The cost of the premium supposed to be pooled with other people's premiums by the administrator, and then the claims are supposed to be paid out of the pool, but the right to the insurance is coming from the purchase of the insurance with which the premium is a consideration as a contract. So I don't know what the fuck he is smoking to say this shit. Also, there is a mortality or risk element involved, and beneficiaries realize a gain or loss because of the sharing of risks through insurance. Fucking moron. That's how insurance works. And he's there saying it like it's some revelation? Idiot. For insurance to work, everybody can't make a claim. If everybody made a claim, and then the insurance would go bankrupt. So what you need is a large group of people, most of whom are healthy, and they pay into it. And the few people that become unhealthy, become disabled, they get the money from the insurance plan, and that's how all insurance works. Now, if you had a car accident and you had car insurance, you get your insurance payment as per the contract. I mean, maybe he's just laying it out because there might be neophytes, beginners reading this stuff. The major questions for consideration are whether premium payments should be deductible. Well, he's saying they should be tax deductible. I guess they weren't before, and they still aren't, by the way. And whether benefits that are ultimately received should be included in income. That's a good question. What you ought to do, if you had any insurance law background, you fucking idiot, is you should have said, what is the purpose of insurance? And then you'd say, well, the purpose of insurance is to repay the person for the loss. And then you'd say, is there any gain involved with the payment of an insurance payment? And then you'd say, well, no, according to the compensation principle of insurance, you cannot achieve more than 100% of what you lost. Now, based on that, there shouldn't be any question of whether it can be included as income, you nincompoop. See, the government wanted to increase the revenue. That's the only thing I can see. And they picked on a vulnerable group. Anyway, the allowance of premium payments as a deduction from income would facilitate the bringing into the tax base of the property income and the mortality gain or loss. Again, go fuck yourself. I'm sure he's dead now, Kenneth fucking Carter. But he is saying that it's property income when they're trying to tell us it's income replacement. It's an income insurance. But here he's saying it's property income. Well, to review some of the things that I've learned after leaving Canada Revenue Agency, Canada taxes 5 different sources of income. The first one is income from employment. Most people fall into that category. They have a contract of employment with the employer. They give the employer service and they get paid, and then they get taxed on that payment. The second one is income from an office of employment, which includes public servants and Canadian Forces and RCMP members. They don't have a contract of employment per se. Well, the public servant might, but the RCMP and the Canadian Forces don't. They own an office of employment, and that office of employment brings with it compensation, pay, remuneration. Now the third one, I'm probably going to forget one of them. Capital gains, that's one form of tax. There's business and there's property tax. Now, so here he's talking about there's going to be property income, but they don't tax it under the property tax law rules. They tax it under the employment rules. They deem it to be income under Section 6 of the Income Tax Act. Now, Section 5 is about income from an office of employment or a contract of employment is to be taxed. Income Tax Act Section 6 is the general part of the act that deems fringe benefits to be part of employment. But here, the Royal Commission was talking about property income. Anyway, as in the case of group pension plans, it is difficult to allocate fairly to each beneficiary his share of both the employer's contribution and the property income, and such allocation should be avoided if at all possible. A procedure that permitted the deduction of all contributions and that brought into income all benefits received would ensure that each beneficiary was taxed only on the net increment to your tax base. Now, it's getting a bit complicated there, so again, he can go fuck himself. But what they did do is my interpretation of what he just said, is they decided that they would allow a tax deduction under Section 61F5 of the Income Tax Act for all career premiums that you pay into a long-term disability insurance plan. So if you were in the military for 20 years, then you get disabled. So you have 20 years worth of premiums that you can claim on your taxes in the first year if you know about it, or in later years if you didn't know about it in the first year. So before you pay taxes, they made a rule that said all of your contributions would be deducted. Now, here's a little story from my own case. don't know the year, probably 2014 or 15 or 16, I called up Manulife and I said, listen, can you send me a statement of my contributions for my service income support insurance plan policy 901102? This asshole I was talking to, what do you want that for taxes? Well, yes, I used to be a Canada Revenue Agency tax collector, and I know you can claim that your contributions, your career contributions from your taxes, you're allowed to claim it. So I'd like a statement, some kind of form, so I can send it in the Canada Revenue Agency to get my deduction. You didn't pay any money anyway, he said. The government paid yours. I said, listen here, you son of a bitch. Are you telling me that the government made that payment out of the goodness of their heart and it wasn't related to my fucking military service? Of course I never got it. But the thing is my plan was twofold. I was looking at claiming the contributions as required in law under Section 61F5 as a backup plan. That wasn't the main goal. But for a reservist, 100% of the premium is paid by the government, and as I said, it's related to my service. And it just so happens that when you pay 100% of the premiums for a long-term disability plan and then you become disabled, you don't get taxed with the money as income. Now, I might get off topic and whatever, and I might be sick and tired of talking about this, but let me explain what I was writing about today in one of my posts. I'm trying to limit myself to a couple of posts today. And I was talking about the fact that a few years ago I was advocating for a veteran and he had a long-term disability insurance required after he left service. He was medically released, and then after he left service, he went to work in the oil sands. Now, when he was working in the oil sands, about a year after that, he got hurt, and then he ended up on long-term disability with Great West Lake. Now, this insurance plan is not taxed, but the Veterans Affairs assholes were deducting his long-term disability, which wasn't taxed, off of his income replacement benefit. Now, when they discovered this, they sent him a refund. Well and good. But when I spoke to the case manager, he said it was because it wasn't taxed under the Income Tax Act. Now, that might seem like common sense, but there's not much difference. A lot of people think money is money. So, they were trying to rely on the income tax treatment. But the income tax treatment is largely up to Canada Revenue Agency. Now, the thing is, if I'm successful in getting this stuff fixed because it shouldn't be taxed, okay, service income support insurance plan, any insurance shouldn't be taxed. First of all, it's not income. How do I know that? Because Cunningham versus Wheeler, Supreme Court of Canada, 1994, had a very simple binary question put before it. Now, it was about damages and long-term disability being deducted from damages. But they had to come up with an answer at the Supreme Court whether the money received in a long-term disability plan was insurance or income. Now, you see how that's relevant to CRA and the Income Tax Act? Because if the money is income, well, it should be taxed under the Income Tax Act. But if the money is insurance, it's not. It shouldn't be taxed under the Income Tax Act because it's not fucking income. Right? But even though the common law is like statutory law, I mean, ignorance of the law is no excuse, right? So they ought not to be able to rely on the fact that they're proceeding as if they're doing nothing wrong. Okay? But it isn't fair. It doesn't help anybody, okay? I get all principled, and it's kind of naive in a way, a lot. But I want things to be black and white, right and wrong, okay? Okay? If insurance was income, I wouldn't be making all this ranting and raving about stuff like that. But it really makes my blood boil when they want to take advantage of someone who has become disabled and to get money off of them in the form of tax when that the money's not income. If it was income, it'd be different. Okay? If it was income, it would have been received in relation to your service. I wouldn't be making the argument that insurance is not income if it was received in relation to your service. Now, I know I can go on and on all day about taxes. Well, I worked at it for 16 years. So, I mean, I have practical experience, and I've been studying it for at least 10 or 12 years besides. Right after I left CRA, I've been reading all these cases. I've been looking up the Income Tax Act and stuff. And, I mean, look at the word periodic, for example. Okay. I'm not entirely sure if this was debated in Parliament, the Income Tax Act, Section 6(1)(f), but somebody put the word periodic in there. Now, when you put a word in a law, laws are not, they're mandatory. It's not like they're suggestion. So, if the word periodic is in there as a condition, a legal condition for taxation of long-term disability insurance, as a fallback measure, as a backup plan, I'm saying that they cannot tax it as if it was paid normally, because Parliament put the word periodic in there. Now, Canada Revenue Agency, in their infinite wisdom in 1979, put out a publication called Income Tax Bulletin 428. And I was typing about it today. Let me see if I got the picture up. But it says, in paragraph, I'll tell you exactly where it is in a second. They said, paragraph 11, if a lump sum is made in lieu of periodic payments, that amount will be considered to be income under paragraph 6(1)(f). Now, I'm not a lawyer, but I know how to read. Periodic is not a one-time payment. So if Parliament put the word periodic in there, it's not up to Canada Revenue Agency to issue a decree here in this income tax bulletin to ignore the will of our elected Parliament. You see? Now, it might not happen a lot, but I had it happen a bunch of times. On my first long-term disability approval for the service income support insurance plan, they delayed it over a year, and I ended up getting like $42,000 in one chunk because it should have been approved as of January 2012, but they didn't give me the money till March or April of 2013. Now, that wasn't my fault. It was their fault because they refused to pay my insurance claim despite my medical release from the military under Queen's Regulation and Orders 15.01, release item 3B, which is too disabled to do your own trade. Now, they should have, in my professional opinion, done what they does for all regular first people and awarded the service income support insurance plan automatically on a medical release. But Section 41A3 of the SISIP policy says that a reservist has to be injured on duty. Now, it's ironic because I used that against Veterans Affairs to say, listen, boys, you say I wasn't hurt on duty, but the Department of National Defense said I was. So the government said it on the one hand, on the left hand, and on the right hand. You did too, but later you revoked that. So the point about, okay, back it up again. Ignorance of the law is no excuse. The word periodic is in the law. Therefore, the people making the payment, they have all the records. So when Manulife was sending me a payment, they know about the word periodic. They know the payment wasn't periodic. So when they issue a T4A for the year 2013, they don't include the non-periodic payment because the law fucking doesn't require it. Now, it just so happens that Manulife is only the agent for the Crown. In that case, they probably sell their own insurance policies, but in the case of policy 901-102, it is the government. Now, get sick of this and hopefully have them warn you all out, or if there's anybody watching, I see Agar's there. Hey, Agar. But the thing is, one of the things, and I get obsessed with things, okay? I got a condition. It's not a disability until it reaches the point where you become too disabled, too occupied, obsessed with, that you can't live your normal life. Okay, it's called obsessive compulsive personality disorder. Normally, it's wanting everything to be black and white, right and wrong. Hard worker never stops working and ends up burning themselves out. That's what OCPD is. Okay, I think it runs in my family, actually. Now, the thing is that what's sticking in my head lately is this affidavit evidence that when they settled the Service Income Support Insurance Plan class action with Dennis Manouge, Federal Court 2012 case, they had these affidavits of settlement. Now, an affidavit is a very important legal document, and you swear on the Bible that this is the truth. Now, in these affidavits, one of them was the defendant, which is Canada, shall retain its usual rights. Let me get it up here to make sure I got it right, because I just saw it a second ago. For medical and financial information, here it is, paragraph 22 of the affidavit. The defendant shall retain its usual rights under SISIP policy 901-102 in relation to the provision of or requests for medical or financial evidence for future payments other than the refund. Now, the refund was the money that they owed to the people that had the Pension Act pension clawed back since 1976 till 2012. So the government, for 36 years, took into account the Pension Act pension to reduce its national defense long-term disability liability. So it wasn't taking the money directly. It was gathering information in violation of the Privacy Act from the veteran about how much money are you getting under the Pension Act. Then they would take that money and reduce the long-term disability insurance that the government was paying through Manulife. You see? So, actually, I just realized that it's not here on this part. But what I was talking about, the through Manulife thing, was I've seen a couple of different pages I took a snapshot of, and it said, well, the defendant, and then comma, through Manulife Financial, comma, will issue T4A slips to the members of the class. The defendant, comma, through Manulife, comma, will issue a refund to the claimant, right? So instead of the government of Canada paying directly the damages that was owed to the people for the breach of contract, they paid it through a third party, Manulife Financial. Now, how is this important? In a number of ways. Okay, on my T4A slip, it says Manulife Financial, but they don't actually pay it. They merely pass the money on from somebody else. Now, I work for Canada Revenue Agency. People had to file taxes, and when you file taxes, you expect people to tell the truth. Now, if you have a T4A that's listed as Manulife, but it was actually paid by somebody other than Manulife, it makes me suspicious. Now, if they're doing this for some nefarious purpose, I can guess at them, but I don't know exactly what they're doing. I don't want to be involved with it. So this is why I asked for my T4A slips to be deleted, like Bruce Bryan had done, because that was the precedent I talked about earlier. Now, I'll mention this and then I'll shut the fuck up. Here's one reason I think that they're ignoring the rules about truthfully putting in, a tax slip. When you, according to the government's own Canada Revenue Agency rules, when you operate a long-term disability insurance plan, and you are also the employer, you are expected to take out employment insurance premiums and Canada pension plan contributions. Now, I don't agree with that rule. I think it's stupid because it's not the two words under two different acts, two different phrases. Under the Employment Insurance Act, it's insurable employment. Under the Canada Pension Plan, it's pensionable earnings. I think it's insurable earnings, okay. So the idea is under each of these acts, you have to have income that's coming in. Now, if you're getting paid from your employer, you get remuneration is the widest possible word for pay. You get remunerated for your time, and then they apply the act and they have a charge of income taxes against your income. Income tax is not part of income. It's a charge against income. Then you have a charge of Canada Pension Plan and a charge of employment insurance. Now, under each of those acts, it's not just the money taken off of you, but the employer must pay more. Under the Employment Insurance Act, it's 140%. So if they take $10 from you, the employer must put $14 with it, and then $24 has to be remitted to Canada Revenue. They say, I was a payroll tax collector. That was what I did for over 10 years. Now, for Canada Pension Plan, it's dollar for dollar. So if you took $10 off for Canada Pension Plan, the employer puts another $10 with it, and $20 has to be submitted to Canada Revenue Agency. Because the money is not the employer's money. The government doesn't own the money. The money belongs to the employee. It's the employee's property. So Canada Revenue Agency calls these accounts trust accounts because the money is being held in trust for the employee. See? So we could have, I used to send out trust examiners sometimes to examine the books and records of employers to make sure they were doing things properly. Because a lot of employers use payroll deductions as a form of cash flow. So in a perfect world, they would set up an account, and as they're paying their money to their employees, they put away the money for CRA in a separate account. And then come time for the money to get sent to remit it to CRA, they could cut a check or pay it electronically or something, and there you go. But if they ran into cash flow problems, the government came last, and they'd use the tax money and the payroll and the EI and the CPP, and then they'd use that to get through their bad spell. It ain't legal, and oftentimes you can't go after, say, if the company goes out of business and it has no assets, how are you going to get the money? So the government gets left holding the bag. Now, it's an interesting thing about these acts that the money doesn't actually have to get there. It's deemed to have been sent in to the government. So even if the employer gets it, steals it, the government can't say, well, you know that tax refund that you wanted, well, your employer didn't send in the money, so you're not getting it. No. People have to trust the tax system, so the government put in there a law that says if the money is deducted, it's deemed to have been sent in to the government. That way, they don't have people, sending in for their tax refund at the end of the year and not getting it. So anyway, I'll mention this one other thing because I got the picture up in front of me. Okay, I'll use an example from the real world. A few years ago, there was a kick-up about male actors in the BBC over in England getting paid more than female actors, and then the male actors said, we're going to take a pay cut so that's all fair. Well, that sounds wonderful, except it ain't fair. In a fair world, the female people would have got paid more to equal the males, and the example from that I'm going to use is a case I was looking up called Schachter, S-C-H-A-C-T-E-R, Supreme Court of Canada, 1992. And there was a woman and a man getting the employment insurance, and they had a child, single parent. And the law gave more money to the woman than the man. Now, I don't know who wrote that stupid fucking law. They should have saw this problem coming a mile away. But It ended up in the Supreme Court of Canada, and they said, I'm paraphrasing, we can fix this in two ways. We can take it from her, or we can give it to him. Now, if we take it from her, it will be equality, but equality with a vengeance, because it's harming her. I agree totally with that statement. Now, let me give you another example. Nobody used this equality with a vengeance thing, and I only popped into my head the other day. And recently I saw that they knew about it for at least 6 years before they fixed it. I was reading through the Hansard, which is a record of parliamentary debate, and it was talking about living death, which is being disabled when you're consuming things like food and whatever, but you don't provide an income. So you're a net liability. So they were talking about that. And they also mentioned the inequality, the unfairness with the Canada Pension Plan versus the Quebec Pension Plan disability. And they said that the flat rate was much higher in Quebec than it is under the Canada Pension Plan. Now, this was 1981. Now, they didn't fix this until 1987. So what took them so long? But here's my equality with the vengeance analogy. Now, they had disabled people in the rest of Canada getting less money, 3 times less money than Quebec. And you had Quebec people that are disabled getting 3 times as much money under the flat rate portion of the Canada Pension Plan disability. So in order to fix that, the government could have done 2 things. Now, it would have been very politically sensitive to take it away from Quebec, right? But they could have said, Quebec, you have to reduce your flat rate to the same as the Canada Pension Plan. That would have been equality with a vengeance. But what they did do was increase the Canada Pension Plan to equal the Quebec disability plan, pension plan disability. Now, the problem with that is, in a perfect world, everybody would have said, this is wonderful, look how good it is. We fixed the problem. But according to Michael J. Prince, who wrote a book on all of this stuff, he said that after this tripling of the flat rate back in 1987, all of a sudden insurance companies and provincial governments turned their sights on the Canada Pension Plan disability. Now, because he said they turned their sights on the Canada Pension Plan disability, I infer the fact that they weren't doing it before. You can have express facts as stated, but sometimes you can use other facts that you know to infer something that is not stated. So I'm saying, it seems to me that he was inferring that nobody was touching the Canada Pension Plan disability. But now they do. And it came about in 1991 or 1993. So the government inserted into the Canada Pension Plan a provision for the assignment of the Canada Pension Plan retroactive to an insurance company. That wasn't right. That shouldn't have happened. People's money in a pension plan is supposed to be protected. That was the subject of one of my posts recently. So you have things like the Universal Law Conference of Canada, who I put the picture of when I found it, that showed, pensions have laws that are meant to protect them. You have things like Canada Pension Plan Act, Section 65(1), that states that nobody can touch the Canada Pension Plan. So if your only money was coming in was Canada Pension Plan disability, and you had a car loan, and you defaulted on the loan, then the car company took you to court. They got a judgment. They then sent a garnishment order to the Canada Pension Plan. Well, Canada Pension Plan say, thank you for going through all that trouble. But Section 65(1) of the Canada Pension Plans can say you can politely go fuck yourself. It's good public policy to protect people's retirement money. So the creditor might not like not being able to go to court and get a judgment and then collecting on the money, but you have to protect people's property. The government is holding somebody else's money, and that makes them a fiduciary. Now, I'm going to get myself wound up again. if I don't watch it, because the government says it's not a fiduciary. But any time that somebody looks after somebody else's money, or somebody has a power imbalance over somebody else, like a doctor and a patient, or a lawyer and a client, that makes the relationship a fiduciary one. Okay, it's not about the money all the time. Sometimes it's about power. So a parent and a child. You have to make sure that you provide a child with the necessities of life. If you don't, you could probably go to jail, but you're definitely breaching your fiduciary duty that you owe to your child. So, let me see. Oh man, that Royal Commission, see, that rots me. Because when I read that in the Supreme Court of Canada case, they glossed it over. I mean, I never noticed it right away. And it seems to me that they're... Okay. Actually, I'm not going to go look at it. But they said that this guy, Carter, recommended that damages be taxed. Now, as I was just talking about, I just saw court awards and compensation. I would also exempt from Income Tax Act an award of a court or a tribunal granted as damages or compensation for the loss of life, or for partial or total disability, or for the loss of a body part. Now, in the Supreme Court of Canada case, they said this guy recommended that this be taxed, when the report itself says he wanted it to be exempt from taxes. We shouldn't be having me explain how the Supreme Court of Canada is causing us to distrust them because of their lies. I mean, how many people are going to go back and review it? Most people are going to take the Supreme Court of Canada's word. I didn't go back and try to find that they were lying. I was just looking up the report to see what it said about taxes. And lo and behold, it jumped out at me that they lied, because they said that, oh, this guy Carter recommended that damages and compensation be taxed. When on paragraph, page 112 of the report, and I was doing a word search, so damages was the word I was searching for. And this guy, D.G. Grant, commissioner, signed off on it saying, we recommend that this be exempt from taxes. Which, by the way, it is. Okay, CRA put out an income tax bulletin like the other one I mentioned, 428, is about long-term disability insurance. But damages is covered under IT 365R2. I got a head for numbers, okay? Okay, it's almost like I got a photographic memory of some of this stuff. So, Income Tax Bulletin 365R2, published in 1985, states that damages is not to be taxed. Now, I've often lamented, why didn't they say why? Not just that it's our edict. We're going to proclaim that it's not taxed. Now, that's good enough for most people. But how about in the Income Tax Bulletin, if they had said, listen, we're not going to tax damages, which is paid to compensate a person who has been injured, because it's a capital receipt and not a receipt of income. Now, they still made their proclamation, but they told us why. Right? Because if you get a payment of damages, it's almost always from someone you don't know. It's not like a contract. It's not like a friend. I mean, you could sue someone as your friend, I suppose. But there has to be a duty of care owed to the person. Then the duty of care has to be breached. And then you have to have suffered monetary damages. Now, that's the three legal requirements for a lawsuit in tort to succeed. So if you sue somebody and you get paid back, you're getting compensated, you're getting made whole by the person who injured you. That is not and can never be income. Can't ever be income. Ever. Never. Because it's not money that you receive from your employer for services, so you're getting compensated for your time. It's not like you're getting interest on money you put in the bank, which is you're getting compensated for the time value of money. You're getting compensated for the injury you suffered. And they can't put you back in the place you were before by magically restoring your body, so they had to pay damages, which is money. Because that's what we're stuck with. Now, I'm paraphrasing, but that comes from the Andrews versus Grandin Toy Supreme Court of Canada 1978 case. And on that note, I think I'm going to call it quits. And look, I sometimes curse and swear, and especially when I get upset. Today I'm doing the hand thing. I don't know why. A lot of times I'm just talking. But I hope I'm not making a fool of myself. Like I'm watching Donald Trump on TV, on YouTube a lot, and man, it seems like his brain is glitching and he's not making sense. Someone like that shouldn't be like the president and having the nuclear codes. Not American, but we live next to him, and I think it'd be good if we had somebody other than a dictator as our leader of our next door neighbor. So the thing is that, well, I'm starting to turn my attention to suing the government or doing something to try to fix this. But I wish I didn't have to, which is why I do these educational type videos. I'm trying to explain to people all of these arcane topics like taxes. Because most people think of taxes and their eyes glaze over. Because nobody can get their head around it. Now, it took a lot of time. I mean, I didn't naturally understand taxes and stuff. And there are things that I don't understand even to today, not about taxes, but like electricity. I can't get my head around electricity concepts at all. Zero comprehension for electricity. But numbers and taxes and stuff, that just clicks with me. I can understand it very easily. But on that note, I'll mention one other thing because it just hit my head. This idiot, Carter, was talking about taxes and stuff on long-term disability. I bet you they never even thought of the fact that the provinces charge premium taxes on insurance. And Canada has a policy of not taxing things twice. So, even if a lot of my other arguments fail, the fact that the government of the provinces taxes the insurance that we buy, and then if you become disabled, you then get insurance. Well, it was already taxed once on the premium. You can't tax it on the insurance. Forget about whether it's income or insurance. You just can't tax it, period. On that note, thanks for watching, and I'll see you next week.